What is the making of Gratian's Decretum? The Making of Gratian's Decretum is a groundbreaking study by Anders Winroth, published in the year 2000, that reinterprets the origins, structure, and editorial history of Gratian's Decretum, the foundational synthesis of medieval canon law. Put simply, it is a philological and historical investigation that shows the Decretum did not spring forth as a single, finished code. Rather, it emerged as a pedagogical text that evolved over time, with at least two major redactions, shaped in a scholastic environment and revised in ways that changed its content and its relationship to Roman law. The short historical prologue is this. Gratian, a master of the 12th century, has long been celebrated as the father of canon law. His great compilation, the Concordia Discordantium Canonum, commonly known as the Decretum, assembles conciliar canons, papal decretals, patristic excerpts, and ecclesiastical customs, and then subjects them to a distinctly scholastic method. Locate apparent contradictions and reconcile them by distinctions, principles, and careful reasoning. From the Middle Ages onward, the Decretum served as the central textbook, and by sheer authority and practice, it became the backbone of ecclesiastical jurisprudence. For a long time, scholars spoke as if there were a single Vulgate text, wholly authored by Gratian and datable to roughly the middle of the 12th century. Winroth dismantles this tidy picture. Gratian indeed composed the work, but its final face is the fruit of a process of classroom elaboration and subsequent editorial augmentation, some of it by hands other than his own, that grafted in Roman law and reshaped the whole. The core thesis can be stated plainly. Winroth argues, on the basis of manuscript evidence and close comparative analysis, that there were at least two principal recensions of the Decretum. The earlier recension shows little or no systematic reliance on Justinian's Roman law. The later recension is fuller and reworked, including Roman citations and categories. Much of that later Romanizing layer, he contends, is not directly by Gratian, but reflects editorial interventions from his academic milieu, likely by students and colleagues, in a setting where teaching and textual expansion were normal. This claim has chronological consequences. The earliest trunk of the Decretum belongs somewhat earlier than many assumed in the central decades of the 12th century, while the expanded version crystallized across the following decade, precisely when revived Roman law was seeping powerfully into the schools. To gauge the force of this revision, one must recall how the Decretum is organized. The work, as it has long been known, falls into three large parts. The first, arranged in distinctions, treats sources of law and ecclesiastical organization. The second, composed of causes, framed as questions, poses hypothetical cases, and explores conflicts of norms on matters such as marriage, vows, jurisdiction, penance, and procedural issues. The third, known as On Consecration, turns to sacramental and liturgical topics. Interwoven with the compiled canons are the celebrated dicta of Gratian, his running commentary that articulates the concord or introduces distinctions and criteria. This architecture served an educational end. It trained students to reconcile authority with authority, text with reason, principle with practice. Winroth shows that parts of this architecture, and many of the Romanizing insertions, are later than the earliest layer. The section On Consecration, for example, bears marks of addition, and many of the Roman citations that stud the received text correspond to a phase when the conversation between canonists and civilian jurists was already intense. In the earlier recension, by contrast, the tone is more purely canonical. Conciliar canons, papal decretals, and patristic teaching dominate the dialogue, and the dialectic centers more on ecclesiological principles than on Roman categories of property, obligations, and civil procedure. The conclusion is not that Gratian was ignorant of Roman law, but that his initial project did not systematize it. The systematization came later, through one or more editorial hands that aligned the Decretum with an increasingly shared legal language in the schools. The method that carries Winroth's argument is itself a major contribution. He does not write history of ideas in the abstract, he writes the material history of a book. He compares manuscript families, identifies passages that appear or vanish between witnesses, measures the density of citations, and tracks the order and placement of materials. With that map, he reconstructs strata of composition. The lesson is larger than this one book. Legal history is not only about great principles, it is also an archaeology of the codices that transmit them. A small shift in where a dictum is positioned, or a newly grafted Roman gloss, can change how a topic is taught, and therefore how cases are decided. In a world where authority was won in the classroom, the editing of a manual could be as performative as a council's decree. From this flow, several big implications. First, a historiographical rebalancing. Standard narratives of the 12th century Renaissance long suggested that the rediscovery of Justinian's Corpus Juris Civilis washed over the canonists, who eagerly adopted its categories. Gratian was imagined as a prime bridge. Winroth complicates the timeline. The crossing was later, and at least in the Decretum, more editorial than authorial. This does not diminish Gratian's genius, it clarifies it. His great achievement was a method of concord applied to canonical materials at hand. That method proved so fecund that, when Roman categories and citations were later embedded, the whole gained new coherence without losing its core identity. Second, doctrinal nuance. If the first recension is less Romanized, then some cardinal solutions in the Decretum arise from distinctly canonical reasoning about perennial problems. Consider marriage. The maxim that consent makes marriage is not merely a late Roman inheritance, but a conclusion from ecclesial sources that privilege the freedom of the bond over formalities. In the later recension, Roman texts reinforce and refine the doctrine, but the vertebrae were already in place. Or take procedure. Rules about proof, the authority of the bishop, and the structure of appeal grow from conciliar and decretal practice. Roman graphs later harmonize and sharpen, but they do not invent ex nihilo. Third, institutional insight. A book born in the classroom and matured in the classroom illuminates the university's role in creating law. The Decretum was not a sovereign's promulgated code. It was a schoolbook that, through utility, became a normative point of reference. The school functioned as a legal workshop. There, texts were collected, copies multiplied, dicta polished, and conversations with civilians became routine. From that ecosystem emerged a legal architecture that bishops and courts would adopt. Authority shifted, in part, from legislative act to academic consensus, a consensus that practice would eventually consolidate. These claims would be thin without concrete illustrations. Let us follow Winroth's logic through several emblematic topics. Begin with matrimonial consent. Canonical sources present tensions, some stress consent, others underscore consummation. Gratian's art of concord distinguishes levels, assigning to consent the essence and to consummation the perfection of the bond. In the later Romanizing layer, one finds contract language and conditions drawn from civil law, but the beating heart remains canonical. Interior freedom generates the tie. This reconciliation does not merely solve a textual snag, it structures social and moral life. Next, episcopal competence and appeals. Some canons confer broad authority on metropolitans, others on diocesan bishops. Still others reserve matters to the apostolic see. Gratian weaves a jurisdictional ladder that honors subsidiarity while recognizing a unifying apex. The later material inserts more technical notions of forum, procedure, and effects of appeal, but the hierarchical equality combined with ordering primacy is not the product of civil codification. It is an ecclesial balance. A third example, simony and irregularities in orders. The sources vehemently condemn the buying and selling of spiritual things, but differ in consequences and remedies. Gratian's concord separates culpabilities, distinguishes invalidity from illicitness, and provides for restitution and penance. Romanizing additions contribute refinements in the law of contract and defects of consent, yet the core moral and sacramental logic, resistant to market reduction, remains canonical. A fourth example, clerical violence and the use of force. Severe canons forbid bloodshed. Others allow the defense of innocence or resistance to tyrants. Gratian articulates a rule that protects clerical meekness without mandating paralysis in the face of grave wrongs. He distinguishes direct participation in bloodshed from limited defense when no other remedy is available, with penalties and dispensations calibrated to circumstances. Later, Romanist hands might offer sharper categories of fault, necessity, and causation, but the pastoral nerve is ecclesial. A fifth example concerns ordeals and irrational proofs. The Church oscillated between toleration, critique, and prohibition. The earliest Decretum already contains seeds of rational rejection of superstition in the name of justice more consonant with reason and dignity. Roman insertions later reinforce concepts of legal proof and testimonial value, but the critical intuition is born of ecclesial discernment. These doctrinal vignettes sit within a rich portrait of the intellectual workshop that explains the textual mutations. Imagine Gratian as teacher, dictating, compiling, arranging. Students debate cases, jot glosses, and compose early summae on the Decretum. A disciple or two propose reordering, adding new citations, introducing Roman passages. Nearby, civilians comment on the digest and code. Their language infuses the common air. In such a milieu, an editor integrates Roman material that equips the Decretum with a shared vocabulary for dialogue across canon and civil. No clean break is needed. The book simply grows into a bridge between worlds that were already conversing in a single campus. Dating shifts accordingly. If the first recension is scantily Romanized, its construction predates the full tide of civil law study, in years when Justinian's texts were returning but had not yet dominated the classroom. The second recension breathes a mixed atmosphere, and its consolidation aligns with a period when the two disciplines rubbed shoulders as a matter of course. This chronological nudge is not antiquarian trivia. It requires us to retell the tempo of the so-called legal revolution of the 12th century, granting the canonistic project a pioneering, not merely derivative role. The book also revises our picture of authorship. Medieval authorial conceptions were porous. Books passed through copying, summarizing, glossing, and correcting hands. Winroth takes that porosity seriously. Gratian is author, yes, but his work is also a product of a school. Revealing the editorial seams does not diminish the master. It humanizes him and situates him in his ecosystem. Often, the best homage to a classic is to return it to its workshop, observing how decisions were made, what was chosen, where a student's hand may have polished a corner. Winroth's philological craft models a method with wide implications for legal studies. A sound textual critique can overturn comfortable doctrines. For centuries, the classical canon law relied on a vulgate. If we reconstruct an earlier stage, interpretations shift. Suppose a dictum long treated as Gratian's turns out to be a later addition. Then we must handle it carefully when reconstructing the master's thought or deriving traditions from it. Suppose a citation of the digest manifests only in the later recension. Then we ought not confuse the original Concord's logic with a Roman graft that buttressed it after the fact. The general moral is this: scholars should practice a layered hermeneutic. Do not simply read. Ask from which stratum a statement descends. Of course, a thesis so strong has provoked debate, which Winroth anticipates and welcomes. Scholars have queried the extent of later editorial hands, the precise geography of the workshop, and the degree of Romanization attributable to Gratian himself. Others note that even a less Romanized earliest layer emerged in an intellectual air already perfumed with Roman categories circulating among disciplines. Such discussions do not undo Winroth's central achievement. They enrich it. A living history of a masterpiece can tolerate reasonable disagreements over borders while benefiting from a map that separates what had long been conflated. Beyond the specialized guild, the book teaches general lessons about law. 1. Grand legal texts often arise from communities of learning. Their authority does not come from a sovereign stroke of pen, but from a disciplinary consensus that iterates, argues, and stabilizes. 2. Cross-tradition engagement, here between canon and Roman law, is most fruitful when seen as a graft onto a robust trunk, not a substitution. 3. Philology is political in the best sense. The material shape of a text influences institutions, lives, and decisions. Deciding whether a dictum is original or added is not a parlor game. It can change the history of matrimonial doctrine, of procedure, or of ecclesiastical governance. Let us dwell briefly on the inner craft of the Decretum, as illuminated by Winroth. Gratian does not merely compile citations. He poses cases and questions. In the causes, he stages ambiguous situations. A vow clashes with filial duty. A bishop overreaches. Conciliar norms tug in different directions. He then supplies canons that press toward conflicting outcomes, and between them his dicta trace the reconciliation. This educative model forms jurists who think. That is why the Decretum imposed itself as the manual. When Roman categories later enter, they land on a prepared dialectical soil. Civil technique organizes and sharpens. The canonical quarry supplies values and ends. Seen this way, Winroth's study rebalances form and content. Form is the composition process, the layers, the order of material. Content is the doctrine. Changing the form can reveal hidden content. The placement of on consecration, for example, affects perceptions of sacramentality's centrality. Its character as an addition repositions certain themes. Or the ordered display of titles and questions in the later recension gives a whiff of system that can obscure the workshop and tentativeness of earliest solutions. After Winroth, teachers and researchers of canon law know that the Decretum's authority lies as much in method as in conclusion. A handful of curiosities, each with explanatory power, round out the picture. First, the earliest summi on the Decretum, penned by close disciples, preserve echoes of the older layer and show how an interpretive community acclimates to a work, glossing and stabilizing it. Second, the hypothetical case, Gratian's preferred instrument, mirrors the theological disputation. Porous boundaries between disciplines were not incidental but reflected a shared mode of thought. Third, the growth of legal teaching in medieval universities created a book economy where copying, glossing, and revising were normal practices. The Decretum both benefited from and shaped that economy. Fourth, the Roman encounter mattered not only by direct citation, but by importing a methodological sensibility, a way of arguing about property, obligation, and person that enriched canonical language. One of the most striking payoffs of Winroth's reconstruction lies in its ethical implications. The Decretum's early core presents a jurisprudence deeply attentive to conscience, pastoral care, and the rule of reason within the Church. Roman elements later discipline and clarify that pastoral law, providing fine-grained distinctions and technical conceptual tools. The synthesis is not a capitulation to foreign categories. It is an enrichment of a living tradition. This image of law as a workshop of reasoned concord, open to learning, wary of domination by any single logic, speaks beyond canon law to the craft of law as such. There are also lessons for reading authority. In many traditions, the prestige of a text freezes it into a monolith. Winroth reanimates the Decretum as an evolving cathedral, a canonical foundation, a nave of concord, Roman chapels added later, stained glass of glosses that refract the light of sources. As with cathedrals, phased construction does not diminish grandeur. It is the source of it. A tradition that forgets its phases risks both arrogance and amnesia. A tradition that remembers how it was made can both conserve and reform with intelligence. Consider, too, the social setting of the Decretum. It is not an ivory tower artifact. It emerged from classrooms that connected to episcopal courts, diocesan administration, monastic governance, and the daily life of clergy and laity. When bishops judged disputes about marriage, property, or clerical discipline, they relied on students trained by the Decretum's method and often on the Decretum itself as a reference. The passage from classroom concord to courtroom decision thus tied pedagogy to justice. Winroth's insistence on the school context does not provincialize the book. It makes visible the channels through which pedagogy shapes institutions. If we draw back and ask what this means for the broader history of law, three threads stand out. First, legal authority is frequently the product of usefulness rather than formal promulgation. The Decretum won authority because it solved real problems with clarity and flexibility. That is an instructive model for any legal system that hopes to maintain legitimacy in the face of complexity. Texts that help users navigate conflict become anchors, whether or not they carry sovereign seals. Second, cross-fertilization between legal traditions works best when rooted in a sturdy, self-confident core. The Decretum's earliest layer was sufficiently coherent that Roman materials could be incorporated without displacing its identity. Today, when legal systems worldwide face transnational influences, the Decretum's story suggests that the healthiest borrowings come not from servile imitation, but from deliberate grafting guided by clear ends. Third, philology is not pedantry. It is institutional memory. Knowing which parts of a text belong to which layer informs how judges, scholars, and teachers weigh them. It helps avoid anachronism and misattribution. It grounds reform in understanding rather than in slogans. Winroth's prose, while meticulous, is also lucid and economical, modeling how to braid micro-level textual details with macro-level institutional narratives. He has a historian's suspicion of monocausal tales. The Romanization of the Decretum is not explained solely by a charismatic editor or a single school. It is the result of converging habits of mind, the availability of books, the prestige of certain disciplines, and the ordinary work of generations of teachers and scribes. He is also careful about what the evidence can and cannot show. Where manuscripts are silent or ambiguous, he does not leap to dramatic claims. That caution, paradoxically, gives his bolder points their persuasive force. Some readers may worry that a layered decretum undermines the stability of canon law's foundations. Winroth's account suggests the opposite. Stability is not the absence of growth, it is the capacity to accommodate growth without losing orientation. The Decretum's method, the habit of reconciling sources, of distinguishing without fragmenting, of balancing authority and reason, proved durable enough to absorb new materials. That durability is what gave classical canon law its longevity, and what allows historians to recognize a tradition's identity across change. For students meeting this subject for the first time, a practical way to use Winroth's insight is to cultivate a habit of asking, whenever one encounters a passage, which layer does this belong to? What problem was it originally solving, and how did later hands reshape it to address new questions? Doing so enriches every doctrinal topic. It reframes the law of marriage as a conversation between freedom and form that deepened over time. It recasts jurisdiction as a negotiated hierarchy rather than a static pyramid. It clarifies the movement away from irrational proofs as the fruit of reasoned pastoral judgment, later strengthened by procedural technique. A final word about the book's wider resonance. The making of Gratian's Decretum appears at the turn of a millennium, a moment when legal scholars across fields were re-examining the origins of their canons and the processes by which texts acquire authority. It could have served only canonists. Instead, it became a touchstone for anyone interested in how legal knowledge is produced, stabilized, and revised. In an age fascinated by codification and anxious about algorithmic opacity, the Decretum's open workshop, revealed by Winroth with patient, careful philology, offers a different image of law, a shared craft, accountable to sources, improved by debate, and revised in public view. Pulling the threads together, here is the concise map. The definition: the making of Gratian's Decretum is a study that explains how the Decretum was composed, layered, and Romanized across time, transforming from an academic synthesis into the central guide of classical canon law. The denials. The Decretum is not a single fixed monument authored in one stroke. Roman influence was not original and total. Authorial sovereignty, in the medieval sense, is not the modern solitary genius. The bridges, a right understanding of the earliest canonical method, shows how later Roman technique could be incorporated. The classroom as workshop explains how editorial communities produce binding texts. Philology becomes a path to responsible doctrinal interpretation. The maxims to take away: look for layers, not just surface. Weigh usefulness as a source of authority. Treat cross-tradition borrowing as grafting on a living trunk. Honor the classroom as a forge of law. And if you seek a closing image, picture a master and his students in a 12th century hall. Books open, cases posed, authorities arrayed. The master proposes a reconciliation, marks a distinction, and assigns a question. A student copies, glosses, rearranges. Another adds a Roman reference learned from a neighbor in the civil law lecture. A scribe in the next town integrates those additions into a new copy. A bishop's court, months later, reaches for that copy to decide a dispute. Centuries on, a historian opens the same line of text and sees, with fresh eyes, the layers that time has laid. That is Winroth's gift. He teaches us to see the living process by which law is made. Above you have more videos to keep learning law. Remember to give us a like and subscribe.